Hey folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. And today again we are continuing with the interpretation of statutes, deeds and documents. Right? And in the immediate preceding lecture we had started with the external aid to interpretation. Remember it? Right? And we have covered the first two aspects of the external aid to interpretation, that is the historical aspect and the earlier and the later act and the analogous act. Right? I hope that was clear with you and you remember it, right? Today we'll move on with the rest of the external aid to interpretation and try to complete the entire thing in this lecture itself. And the students who have been following with me throughout the lecture, for them, welcome to this lecture, and the rest who have not been following me throughout the lectures, please go back, refer to the previous lectures that you have missed, and then come back to this, because those lectures were definitely more important lectures. Right? So, when we start, we see the external aid to the interpretation of statute, and I will again show you what are the six of them. That is the historical setting, earlier and later act and analogous act, the usage, the reference to other acts, dictionary definition and the judicial pronouncements. Right? Although we'll not go in the serial number with our discussion. And then we had done the historical setting, right? We understood the entire historical setting, that is the parliamentary history, historical facts, statements of object and reason, and the report of expert committees. And I hope all these 4 points are very well and very in-depth clear to you. And you know what is the statement of object and reason which is attached to the bill. You know who is the expert committee and what do they do. Right? So we had done with that already, and then we had also discussed the earlier and the later act and the analogous act. And in its explanation we have also included the concept of the change in technology and the social condition. So we say that we need to interpret it in accordance with the change in the situation since the enactment of the act. And we have taken an example from the Indian Evidence Act 1872 that was regarding the handwriting and the typewriting. Right? They mentioned about handwriting, but we construed it to be typewriting after the concept of typewriting had come into India. Agreed with that? Okay. So next point that we take up today would be the dictionary definition. And when we talk about the dictionary definition, we talk about the three aspects. One is the statutory definition, the definition which is provided by the statute, the judicial decisions that have been taken by the court, and the dictionary definition itself. Right? So these are three places of reference to understand the meaning of any particular word. Because when we talk about definition is actually defining a single word. Right? So these are the steps that will be followed, and these are the procedure that will be, and these are the impact of the dictionary definition in the interpretation of the statute. Right? One is the statutory definition, the other is the judicial definition, judicial decision, and the third is the dictionary definition. Now let us analyze each one of them in detail. So first, when we go with these three aspects, right, you need to understand the priority and the weightage. So the topmost priority and the maximum weightage should be given to the statutory definition. And if it is not available or if it is ambiguous, you move on to the judicial decision, if any. And if you do not have any judicial decision too on that matter, then as a last resort you refer to the dictionary definition. Right? Now when we talk about the statutory definition, so what do you think is the statutory definition? Yes, exactly, this is the definitional section that we are talking about. Right? So what the statute goes ahead to define for a particular word will be used. So this is actually the internal aid, and we have also referred to this in the internal aid of interpretation. Right? And that is why the name of the heading is given as the dictionary definition, because that is an external aid. Right? But we will not talk about the dictionary definition in isolation. because in a general rule, as per the general rule, you cannot resort to the dictionary definition for any meaning of the word which is used in the statute, right? Because the intent, purpose, scope, objective of that word are way beyond, they are very different, whereas the words in the dictionary are very general words, right? So whatever is specified or mentioned in the statute itself will be the first priority for us. So if there is any word that is difficult for us to understand, we move on to see the definition given in the statute. And if we find a definition, and again for definition, you remember they have two types of definition. One is the inclusive definition and the other is the exclusive definition. So in the inclusive definition, that starts with the word include, like the definition of the word transfer in the Prevention of Money Laundering Act, right? So when we talk about it includes, that means we are talking about one particular aspect of that definition and not the meaning or the exact intent of the definition. So you'll say, okay, it includes this, but there are other things as well, right? And when we talk about the exhaustive definition, it says this thing means, like the example of the definition of banking in the Banking Regulation Act, right? Banking means the borrowing, lending of money, public, all those things, right? You remember it? Do you want me to remind it? Forget it, we are not in that chapter now, right? So you understand that these definitions are basically the statutory definition, the definition that has been provided in the statute by the legislature itself, right? Now consider a situation when you are trying to interpret a word, you are trying to look for its the statutory definition, but either you don't get any, or the one you get, you can't rely on it, or you are not able to interpret even the definition. Why? Because the words that are used are very ambiguous and you cannot reach a specific conclusion using those words, right? So in that point of time it becomes a task. So you refer to any judicial decision if available, right? So if any similar matter has been taken to the court, right, then what has the court talked about in reference to this subject matter? What is it that the court has to say, right? So if you find that yes, the court in the past has taken a decision considering a specific meaning of the word, right, then you can take up the same meaning. But there is a condition for that the context in which it was used at that point of time should be the same context in which you are trying to use it over here, right? So if it is the same context, then you can refer to the judicial decision. But you went out in the search of a judicial decision, but what if you do not find one? Right? That means you do not find any judicial decision on the same subject matter or on the same topic that has been held earlier. So it's a fresh thing, right? But suppose if you do not have anything containing the judicial decision, neither do you have anything in the statute, or even if you have something in the statute that is ambiguous, right, then at the end, at last, when you have no way out, you refer to the dictionary definition. Now what happens is whenever you go and you refer to the dictionary, right, you have a lot of meanings given over there, right? Then it is your task to pick up the most appropriate meaning from those other definitions, right? So which is the definition that suits the purpose, that suits the current scenario, will be picked up, right? Are you getting my point? And then you will try and understand and interpret each one of those words, and you'll also try to link it with your statute. You'll try to link it, okay, where is it applicable, what is the applicability, what has to be included, what has not to be included. All these things will become your responsibility, right? So you resort to the dictionary definition only when there is no judicial decision by the court and there is no statutory definition of that specific word that you have taken away, right? So I hope the meaning of the dictionary definition is clear with you. So we are done with the dictionary definition and we move ahead to the next topic, that is the next external aid of interpretation, which is the reference to other acts. And when we are actually referring to the other acts, there are various other aspects, various different aspects that we need to consider, right? And those aspects are there on your screen. So we'll see, or we'll talk about the matter that arises when we talk about the Composite Act, the incorporation into another act, the Consolidating Acts, when earlier act is replaced, and when we have a reference to the repealed act. So when we talk about the Composite Act, right, that means there are two acts that has to be referred to simultaneously. That means side by side, right? They are composite acts and that will be applicable in the particular situation. So whenever we are referring to any composite act, right, for any particular topic, then we will have to make sure that we read both the acts together and then form a common interpretation, right? That would also mean that the common part, that means every part of each act, has to be construed as if it is contained in one composite act itself. So you'll combine both the act and create and read it as if it was just one composite act, and you get the interpretation out of it, right? But if both the acts are flowing in two different directions, if they are on two different tangents, then you cannot fulfill your purpose. Basically, I'm talking about a harmonious construction in this point of time. If you actually go to the background and try and interpret what they are saying, then they are talking about the harmonious construction, right? And then they say that if there is any clear discrepancy, then the act which was enacted later in the point of time, right, would modify the earlier act. That means you would refer to the act which was enacted later in the point of time. But again, over there you have to be very careful that maybe the entire act was enacted later, but the specific provision that you are dealing with, right, has been amended in the previous act, and that amendment took place after the enactment of the new act. So which is a new provision? It is a provision of the old act, right? So when we are talking about to focus or to give an advantage to the act that has been prepared later in the point of time, then we are not talking about the entire act, but we are talking about the enactment of the particular provision, right? So we are dealing on the small level with the provision. We are not going on the mega level to the entire act, right? So that is the meaning of the Composite Act. Next you have an incorporation into another act. Now this is somewhere where you have to be a little careful, right? In the general interpretation, even you would have deviated, but I'll tell you the real meaning of incorporation. So understand, right, at any point of time, if you have any particular provision of one act which is incorporated into another act, right, say act number 1 and act number 2. So any particular provision from act number 1, right, that has been picked up and as it is incorporated in act number 2, right? So in that case, the provision of the first act that has been incorporated will be read in the same way as it was read when it was in the previous act. That means the first act, right? It will always be referred to in that provision, right? So when you are referring to that particular provision of the first act, then to interpret or to construe the meaning of that particular provision, you will have to relate it to the entire act, the entire previous act, and not the new act. Why? Because in the new act it is a foreign element that has been incorporated, right? And at this point of time it will not be convenient for you to get into a whole new research behind the thing, right? So what you do is you interpret the provision of the first act the way it used to be interpreted in the previous act, right? So that is the main external aid, because if you would have to refer to the current act, then that is an internal aid. But since that specific provision has been incorporated from some other act, you have to take an external aid and go and read the other external act, right? Are you able to link the difference between the internal and the external factor, the internal and the external aid to your interpretation, right? And if you can actually do it, then you have already understood the topic, right? And don't worry if you're not able to still identify it. We still have few topics to go where you will be into a habit of the same, right? Then after incorporation into another act, we now have to see the consolidating acts. So when we talk about the consolidating act, right, you know the meaning of consolidation. That means you will consolidate one act into another act, right? Like you consolidate the balance sheet of the head office in the branch, in the similar way you will consolidate the entire act. Section by section, provision by provision, you will keep matching it and consolidating both the act to form one common act, right? That will actually be a stronger and a more relevant act, right? So now whenever you are consolidating an act, try and understand one thing, that you are not intended to modify the previous act, right? Because when you're consolidating, you're picking up points from that act and you are incorporating it into the new act. So there are two acts that are merging together. None of them is being modified. None of them is being changed. So no interpretation of any of those acts individually will change, right? Neither in the individual life nor after their consolidation, right? So if two acts are consolidated, then you will have to refer to each individual provision for each individual task. Getting the point? Okay. The next topic that we need to consider is what happens when an earlier act is replaced, right? That means an earlier act is replaced by a new act, or it would actually be when the earlier act is explained and not replaced, right? Because when it is replaced, it loses all its value, so you're not referring to it now anymore. But when it is explained, that means you had one act and now you have another act that is dealing with any topic, that doesn't matter, but that act is actually explaining some provisions from the previous act, right? So in that case, the later act, right, that will be used to explain the previous act if they are talking on the same tangent. Even if you would have used the word replaced over here, that would not be wrong for you, right? But the point is that the new act is explaining the previous act. And one more fact is that yes, the new act has replaced the old act. But since it is explaining some of the provisions of the previous act, so we will construe it accordingly and interpret it according to the situation, right? Now the last point over here that we have is a reference to the repealed act. Now when we talk about the repealed act, right, we are not trying to intend that the entire act has been repealed or removed, right? We're talking about some specific provisions that have been removed, the specific provisions that have been repealed, right? So if you are referring to an act and certain provisions of the same act has already been repealed, so that becomes now an external aid instead of an internal part, right? Because it is no more a part or the context of the same statutory text. So we'll not call it an internal aid, we'll call it an external aid if it can help, right? Now what can it help? Now whenever an act is created, whenever we refer to the statute, right, when we were discussing the internal aid, there's one point at the end that I discussed, that you will have to read the entire statute on the whole, right? That means if one part of the act or one provision of the act is repealed, there may be an impact on some other provision of the act, right? So although if this part is repealed, this part becomes useless for you, you will not be interpreting or using this portion of law, right? But for the other portion that is already continuing over here, that has not been repealed, if you want to interpret that portion, you can again refer to the portion that has been repealed, right? Because the law has, or the statute has told you that you cannot use this portion because it has been removed or taken back, right? But that can be used for interpreting some other non-repealed question, right, or the provision. So do you understand now what are the cases when we talk about the reference to other act? Number one, when it is a composite act, that means two acts working parallelly. Number two, incorporation into another act, that means a small portion is incorporated into another act, but when you have to refer to it, you'll have to refer to the entire previous act. And that previous act is not the main act, and hence it is an external aid. Then you have consolidating act, where two acts, they come and they merge and they combine, right? None of them lose their value. Getting the point? So those are consolidating act, and you'll have to refer to each one of them in parallel with the others, right? The acts that have been consolidated. It is not necessary that only two acts could consolidate, right? Even more than two acts, like 3, 4, 5 acts can also consolidate if it becomes possible and if they are on a very close thin line, right? Then we have when earlier act is explained, that you had an act earlier but now you have a new enactment that is replacing the previous act. But if you have any question on the interpretation of the previous act, then for those things you will not refer, or you will refer to the new act, the provisions that have been provided over there, right? And at last you have the reference to the repealed act. So since you are asked to read the statute on the whole, so even if there is a repealed act, right, then they may be trying to hide over here, hide in the sense of they are still present with the repealed act. So if you have to make any interpretation of the repealed act, you may have to refer to the if you have to make an interpretation to the non-repealed act, right, the act which is continuing, you may have to refer to the repealed act. And if it has already been repealed, it is no more a part of the main act, and hence it will always be termed as a repealed act. You cannot take the position of the new act, right? So that is all about the reference to the other acts. Now we still have one more external aid, that is the judicial pronouncements, right? And it has certain parts like the reference to the enactment and the reference to the decisions. That may be the Indian decision and it may also be the foreign decisions. So when you are referring to any decision for your statute, those are the external aid, right? But we'll take up the discussion of this topic in the later class, in the next lecture, right? I would have completed even with this portion in the current lecture, but you still remember that you have to be done with the points that has been given by the institute in the practice material or in the study material over there, right? So even when I'm discussing those points, I'll give you a brief about those points as well. So if the judicial pronouncement is not taking much of time, but that particular point will take some time, and that will go beyond the time that we have for the class, right? So instead, let us leave this video on a shorter length, and we will come back with the next video, and there we'll discuss about the judicial pronouncements and the exact terms used in the study material with a brief description about the same. Okay with it? I know with this you say, okay, we have extended to one more class, but we could have completed it in 2 classes. Exactly, I agree with you. We could have completed it in 2 classes if we would have extended the class, right? But again, what would have been left is the study material, which is the granth for you actually, right? That is something that you have to refer, and that is something that is the only thing that is sure shot to fetch you marks, right? Don't worry whether it's right or wrong, but whatever it is, that is something that will fetch you the marks, right? So please stay tuned for the next lecture. Until then, this is Abhinay Gupta signing off. Thank you and bye-bye.